SMU constitutional law professor Dale Carpenter, thank you so much for joining us. As you know, the House is going to be voting on impeachment today. It looks like the Democrats will have the votes, just as they did last night on the 25th Amendment, to impeach the president twice. This has never happened before.
Never happened in the history of the country, to any level, at any official at any level in the United States government.
And so talk to me a little bit about, this being unprecedented.
Well, of course, there's precedent for impeachment, and there's precedent for even a presidential impeachment. It's happened to three different presidents. It happened to Andrew Johnson, it happened to Bill Clinton, and it has previously happened to Donald Trump. But there's no precedent for a president or any other official to have been impeached twice. The House of Representatives has the sole power to bring an impeachment, which, remember, is nothing more than the bringing of a charge against a president for high crimes and misdemeanors.
And, usually this is, from what I've read, a very time-consuming process. We saw that the first time President Trump was impeached. The fact now that they want to do this right away, what does that say?
Well, once again, it's another way in which we are confronting an unprecedented situation. The time crunch here is the view, at least by many people, that the president constitutes an ongoing threat. And even more than that, I think that President Trump's actions are things for which he needs to be held accountable. And it needs to be made very clear that no president should ever commit an act like the ones he is charged with committing.
And as far as, the timing of all of this, if the House does, in fact, impeach the president today, which it certainly looks like is going to happen, so they don't have to send the articles right away, as we saw the first time around. If the House decides to wait and send it, after President Biden's 100 days, as has been discussed and proposed, can the Senate still impeach, can still convict after the president leaves office?
That is yet another area in which we have not zero precedent, but very little precedent. I think the view of most scholars is that yes, the president, in fact, can be convicted after he leaves office. The conviction would not be moot, that is, it would not be pointless, because although he will already have left office, and so he wouldn't be subject to removal because he will already have left, he is subject, upon conviction, to the further punishment that he is disqualified from holding future federal office. So that could be a consequence of his conviction in the Senate. And of course, he would become the first president ever convicted on impeachment, because the prior three presidents, including Trump, have been acquitted in the Senate, sometimes by narrow votes, but they've been acquitted. So the thinking of most scholars, I think, is that yes, he can be convicted even after leaving office, but there is some doubt about that. And I think one of the arguments will be that he should not even have a trial held after he leaves office.
And right, because that would have to be in the Senate. And again, I guess the Senate could decide whether they hold a trial or not. All they have to do is consider it, right?
That's right. The Senate's consideration of this matter is entirely up to the Senate. The House has the sole power, the Constitution makes this clear, the sole power to bring an impeachment. The Senate has the sole power to try an impeachment. So that governs all aspects of the Senate trial. And the Supreme Court has said that it is never going to get involved in these Senate trials of impeachments. That's just not an area. That's an area entirely for the discretion of the Congress.
Now, the other scenario that has been discussed is basically having the Senate consider all of this before the president leaves. But we've seen that the first consideration, as of right now, would be the day before the inauguration, before he leaves office. And I guess with the Senate rule, it would be after, I think it would be 1 p.m. after the inauguration. So if that's the case, then the Senate could just wipe its hands too and not act at all.
Conceivably it could. I think the precedent of the Senate is that it does consider all articles of impeachment from the House. So unless the Senate changed its rules, its own historical rules for some reason, I think it will consider these articles of impeachment. The only question is at what time it will do so. And it's interesting to note that the vote on convicting the president on the article of impeachment sent over from the House is one vote. That requires a 2/3 vote in the Senate of the senators present. The vote on disqualifying the president from future office would be a separate vote after the conviction. And according to the precedent that's been set, that probably only would require a majority vote of the senators.
I was just going to ask you about that. So perfect timing. And I also wanted to ask you with regards to, we're talking about an impeachable offense, and that's crimes of high crimes and misdemeanors. Besides this being political, I know there's also the standard of, was what the president did criminal? Could he be prosecuted as a criminal after he leaves office?
Yes. So the view of most scholars, just on the question of impeachment, the view of most scholars is that it's entirely up to the judgment of the House and the Senate to decide what constitutes a high crime or misdemeanor. And they are not necessarily limited to a federal prosecutable offense when they decide on impeachment and conviction in Congress. The question you ask, though, I think is separate, independent of whether or not the president is impeached and or convicted in the Senate. Can the Justice Department, a U.S. attorney, bring a criminal indictment, a criminal prosecution against a former president of the United States? And the answer to that, the overwhelming answer to that from most scholars and authorities in the Justice Department and elsewhere is that yes, a former president could conceivably be indicted and prosecuted and punished for crimes that he committed while in office, at least after he's left office.
And what would that have to be a federal charge? Because the president spoke at the White House ellipse before the violent attack on the Capitol. And so if you're in Washington, D.C., it would still have to be a federal charge. There are no local charges, right?
That's right. The events that occurred on January 6th and to some extent in the run-up to January 6th would involve federal charges. They would involve charges of inciting to insurrection, inciting to violence, and all kind, maybe conspiracy. We'll see. I don't know what they're going to come up with, but there are multiple federal criminal violations that may have occurred for people who attended or spoke at that rally that the president had last Wednesday, and those involved in, of course, the storming of the Capitol, the attack on the offices, the threats against the vice president and others in Congress. Those would be separate decisions, and those are separate federal crimes. The president is not immune, so far as we can tell, from criminal liability for acts that he commits even while he's president.
So this raises the question that has come up recently, and that is, can the president issue a self-pardon? Can he pardon himself so that he would not face any federal charges after leaving office?
Well, you've just asked one question after another that would make good law school exams, quite frankly, because we have never confronted a situation like this. No president has ever actually tried to pardon himself. several different presidents, even presidents over the last 50 years, have had potential criminal liability. So think, for example, of Richard Nixon, who faced liability over the Watergate scandal. Think, for example, of the first president, George Bush, who faced potential federal criminal liability over the Iran-Contra scandal. And think of President Bill Clinton, who faced potential liability over the Whitewater investigation. There was some discussion in the White House and among aides about the president possibly trying to pardon himself for those offenses. No president ever actually did so. President Nixon was pardoned only by his successor, Vice President Ford, who then became president when Nixon resigned. The president is given the authority under Article 2 of the Constitution to issue, he's given the power to issue pardons and reprieves against offenses, for offenses against the United States, meaning for federal crimes, not for state crimes. So we're not talking about investigations for which the president may be liable criminally in the states, like in New York, for example, but for federal crimes. That's the kind of power that the president would have conceivably. I think the better view and the view of most scholars and the tentative view of the Justice Department back when Nixon was being investigated is that, in fact, the president does not have the authority to pardon himself. And that's for a couple of different reasons. The nature of a pardon is the granting of clemency or mercy to another person, not the granting of clemency or mercy to oneself. That's just the nature of a pardon. If the president were able to pardon himself, that would effectively place him above the law. It would allow him to commit criminal acts and then excuse himself from any such criminal acts. And one principle of American government is that the very reason we had a revolution is that that kind of monarchical power in which the king could not be subject to prosecution in the king's own courts was something that we completely rejected. So it would be alien to American history and the very pardon power that was borrowed from English history. Also, there's a fundamental principle of the American legal system that says this: a man cannot be a judge in his own case. You are not entitled to sit in judgment over charges against you. So allowing the president to pardon himself would effectively be saying he is the judge of his own case. He is the one who gets to determine his own fate. That's a cardinal legal principle that frankly has never been tested, and probably for good reason. Very few presidents, I think, ever thought they had the power to do it, and it probably would not have occurred to the framers that a president could ever do such a thing.
And of course, then this goes back to what a President Biden would do and whether he would have his Justice Department seek charges against President Trump after leaving office.
Yeah, President-elect Biden at this point has said that my Justice Department is going to be independent. I'm going to let them make the calls about prosecuting offenses. I'm not going to get involved in those prosecutions. I don't want this to be my job. I want them to speak for the law, to defend the law, and not to defend me. He has said that.
But ultimately, it's that then would really cause, I would imagine, politically a lot of stir in the country between Democrats and Republicans, and it would be a political decision on, a President Biden, obviously, once he's in office, to consider all that.
There is no doubt that the prosecution of a president would be an unprecedented thing again in the history of this country. Richard Nixon could have been prosecuted after he left office. He was only not prosecuted because he was pardoned by President Ford. So we never tested that proposition whether a president could or should be prosecuted. I will say President Trump will have potential defenses against a prosecution. One of them, of course, would be if he issues his own pardon, he'll argue that the prosecution should be dismissed because I have pardoned myself and so I'm not subject to prosecution. The judge should just simply dismiss it. Another would be that a grand jury may decide there's not enough here for a president to be charged. Another might be that the judge might say these charges are not sufficiently meritorious to bring a prosecution. Another would be that the president would say, just on the merits of the case, I did not actually incite a riot. I don't meet the legal elements that are required for incitement of riot, even if my name were Joe Smith instead of Donald Trump. So he would have a range of offenses. And of course, the Justice Department would have to make a very careful, calculated decision about A, whether there was a sufficient ground to bring a charge, and B, whether it was prudential and wise to do so, and C, whether the Justice Department had the power to prosecute a president, even perhaps in the face of a quote unquote self-pardon.
And that could be a case that would make it all the way to the Supreme Court.
Oh, there's no question. If the president is charged with a crime and is being prosecuted, Donald Trump will certainly take this as far as he needs to go in order to stop that prosecution, and we'll see what happens. That will be a very interesting constitutional moment in our history, if and when it occurs.
Did want to ask you a couple other questions, and that was about the 25th Amendment. And last night, House Democrats voted to urge Vice President Mike Pence to invoke the 25th Amendment. They passed that, but the Vice President has said, he wrote to Congress saying he's not going to do that. And so my question to you is, if that were to be the case, we've heard a lot of that this would remove the president. It wouldn't remove the president, right? It would just strip the president of his powers. And is there a difference?
Well, there may be a titular difference. I don't think there's a substantive difference, because if Mike Pence and the cabinet, a majority of the cabinet, were to agree to invoke the 25th Amendment because the president's deemed to be unfit to carry out his duties as president, Mike Pence would immediately assume the responsibilities of the executive branch, the presidency, and he would become the quote unquote acting president. If Donald Trump then objected and said, no, I am fit to serve, then the vice president could say, no, we actually think that you are unfit to serve. And then for at least a period of a few days, Mike Pence would reassume the duties again of President of the United States, or the acting presidency of the United States. And then there's a process in Congress that takes about 3 weeks for that to work itself out. And of course, by then, President Trump will have long been gone, because his term will have ended. So if Mike Pence doesn't invoke the 25th Amendment, obviously this is a moot point. It seems like he's not going to do so. If he does invoke the 25th Amendment successfully, then it's also a moot point in the sense that he would immediately assume the duties of president, and Donald Trump will have left by the time he would have reassumed the duties of president. And he may still be subject to impeachment and trial in the Senate and prosecution after he leaves office. It could be a triple threat.
One other question I had, and that was just about the censure. Some Republicans in Congress have proposed that. What exactly entails a censure?
Well, there is one president in the history of the country. So there is precedent finally for something. There is one president in the history of the country, and that was Andrew Jackson, who was formally censured by the Congress. And a censure is just a formal condemnation of another person's acts. Typically, a censure is issued against a member of the very body that issues the censure. So it would be issued against a member of the Senate, or issued against a member of the House. But there is precedent for a president being censured. At least it did happen 180 years ago. So it could happen. It's more harsh than just a simple rebuke. Congress could vote for a rebuke. And it's less harsh than what has happened to some members, expulsion. You can actually be expelled, but of course the president can't be expelled from the Congress, and he can't just simply be expelled from the presidency. That requires the 25th Amendment or conviction on impeachment.
I did have one other question, Professor. Just looking ahead to the inauguration, President Trump has said he's not going to Joe Biden and Kamala Harris's inauguration. But Vice President Pence is going. There's nothing in the Constitution that requires an outgoing president to be there at the incoming president's inauguration. Is that right?
That's right. There's no requirement. There's no requirement that a former president be there. They always have been. Well,
Not always, right?
at least in the past 150 some odd years, I think they've always been there. Sometimes they've been very frosty relations. I think Harry Truman and Dwight Eisenhower didn't even speak to each other, but they have always gone, except in the 19th century. But since then, they've always gone. But there's no requirement that they go.
Dale Carpenter, SMU constitutional law scholar and professor, we appreciate your time very much. Thank you so much.
My pleasure.